Hey there, this is Pat Ennis of Ennis Legacy Partners. Welcome to the Exit Readiness podcast. I'm here with co-host Walter Dial, who is a tax partner at GRF CPAs and Advisors here in Bethesda, Maryland. And my business partner, Corby McGordon, is also with us here today. Our mission here on the podcast is to provide you, the business owner, with subject matter expertise on topics pertaining to building sellable or transferable business value, and then for planning your eventual exit from the business. We want to help you build a business that's transferable and then exit successfully on your own terms and conditions. Non-qualified deferred compensation. Non-qualified deferred compensation is something that we talk about fairly often in client engagements. It's an unfunded, unsecured promise by the employer to a key employee or key employees to pay compensation at a specific time or a specific event in the future. The program is a contract between the employer and the key employee for the payment of future benefits. And as we help business owners plan for their exit, non-qualified deferred compensation can be a very viable solution for a number of different issues or planning challenges, such as attracting, retaining, rewarding key employees. It can also be a key piece in structuring an internal sale where key employees or children are going to be buying the business from the departing owner. And however, non-qualified deferred compensation has a few disadvantages or planning challenges. And we're going to mention those today in a couple of minutes. But also today, we're going to hear from an expert who we've had here with us before. Today, we're going to hear from Larry on an alternative solution for deferred compensation that addresses at least some of these disadvantages. That's what we're going to discuss today. Our topic is an alternative to non-qualified deferred compensation. And our guest, again, he's been with us before, Larry Bell, excuse me, of Advisor Solutions. Larry's one of these people who have more letters behind his name than he has in his name. He's an attorney. He's a certified financial planner. He's a chartered life underwriter. He's an accredited estate planner, among many other things. And so with all that knowledge and expertise, Larry actually teaches other professionals, including actuaries. He's a qualified subject matter expert for the Certified Financial Planning Board. He's authored numerous articles on 409A of the code, benefit planning, and he speaks nationally on all these different topics that he's written on and he knows about. He served on various tax and taxpayer volunteer liaison roles in Maryland and with the IRS, and actually he has patents in actuarial. I have a hard time even saying actuarial. Always have products. He has patents. You got to be really smart to have a patent in an actuarial product. And so he works alongside advisors like us in serving business owners like we serve, as well as nonprofit organizations, government organizations in strategic planning, business continuity issues, benefits, on a regional, national, and international basis. So it's great to have him with us. He's got a ton of expertise, and we're going to just draw a little bit of that out of him today. So Larry, welcome back. Did I miss anything in that intro, Larry?
I'm a very, I'm a very proud father and grandfather, which is probably the most important. But no, that describes much of my ongoing career. Thank you very much, Pat. It's nice to be back.
Very good. Thanks, Larry. So Larry, as I mentioned in the opening comments, and of course we've talked about many times offline, in the work we do, non-qualified deferred comp plans can play a key role in facilitating an internal sale, transfer to kids, as a piece to the comprehensive exit planning puzzle for a professional services firm. It can also be used to attract and retain key employees. However, there are those disadvantages that we're going to we're going to mention here, and which need to be understood and planned for, including disadvantages, including for the employee, the amount of compensation that is deferred is an unsecured contractual obligation of the employer, so that any amounts that are set aside to pay out future benefits are not protected from the claims of general creditors of the business or the organization. That's for the employee. That's one key disadvantage for the employee. For the employer, the ability to discriminate is an advantage. Who on the team is going to be eligible, but that comes with the price of no current tax deduction to the employer for any amounts that they may set aside to pay future benefits from the plan. And though, if funds are set aside, or if the plan is formally funded, if you will, any investment earnings on that amount of money could be taxable income to the employer. And also the requirements of 409A code, IRS code 409A, raise the risk of adverse tax consequences to the key employee as a result of an error in plan design or administration. So I know you understand those disadvantages probably better than all of us do. So Larry, we want to review with you today another solution that you've used now for the last 15 years at least, that has the benefits of a non-qualified plan, looks like non-qualified deferred compensation, while at the same time addresses at least a couple of these disadvantages I just mentioned. So Larry, I'm wondering if the best place to begin our conversation here today is with you just, in your own words, briefly describing the problem or problems we can indeed address with the solution that you're going to review with us today.
Thank you very much. Back at the time that Walter and I started practicing, there was no bright line test. There was no codification of deferred compensation generally for either profit or nonprofit. It's only been in the last 20 years that 409 Cap A became the law and codified the rules that we had to follow. In a similar approach for nonprofits, the codification of deferred compensation is set forth under 457 and 457F. That occurred back in 1983, and before the legislation, we had to rely on court cases and IRS rulings and directions and some court cases. Back in 1992, the Department of Treasury gave a report to Congress discussing deferred compensation for nonprofits. And they're buried down in the bottom, said that a bona fide death benefit plan is not required to follow the deferred comp rules. Fast forward to Notice 2005-1, which gave us direction for profits, and it incorporated by reference bona fide death benefit plans under 409 Cap A D1 as not having to follow the deferred comp rules. So through my work, through my successes, we are able to provide a permissibly selective benefit for top hat employees. And that's a term of art, which covers management, professional, and executives. And what this does is it permits the funding of the benefit to be owned by the executive, the management, or the professional. And it can be an independent contractor under the statute. And then the employer If they're for-profit, can deduct the cost of the current death benefit. And if it's a nonprofit, they can expense that amount. That is either a deduction or an expense. The only tax to the participant during that funding period will be the economic benefit. This was further set forth in 1997 in the neonatology case. So we now, with the passing of the proposed final regulations for 457F, and then the Tax Cut and Jobs Act, have a bright line test that we can follow to provide a benefit in a non-qualified, non-deferred comp platform. So it has application in many, many employer-employee situations. Because this reaches back to code back in the 90s, we actually have guidance so that we can have it being permissibly selective and not being an asset on the books of the employer. That's important because, as you set forth with a deferred comp arrangement, that asset is available to the claims of creditors unless you utilize a rabbi trust, and even then it may be subject to the claims of creditors. So this gives more control and flexibility to both the employer and the employee.
So, Larry, just you mentioned like in the nonprofit world, could you give us an example of a nonprofit executive then, and just what it might practically look like? What that, I'm a numbers guy, so what might it look like for an executive and to implement this type of plan?
With an executive in a nonprofit, there's actually a number of different results that occur. Under the Tax Cut and Jobs Act, any of the top 5 executives that receive remuneration of more than $1 million, that will immediately trigger an excise tax to be paid by the employer of 21% of the remuneration over $1 million. Washington metropolitan area has a large number of nonprofits. Nonprofits don't mean that an employee can't make a lot of money. There are other rules that you got to follow to do that. From the standpoint, the code also and the direction from the service indicates that the benefit arrangement that I've described, a bona fide death benefit plan, can be funded by a employer funding or by a salary reduction. So that to the participant, if it's not being funded at all or in part by a bonus contribution, the employee can take a salary reduction. And because this has been codified, we avoid the constructive receipt rules, which is always a gotcha in deferred compensation when we're trying to put bells or whistles on it. With a premium contribution of, let's say, $100,000. You got an executive, if he's making $1,100,000, by reducing that $100,000 salary, the excise tax at the employer level is reduced $21,000 that otherwise they could use for other exempt purposes. The executive is reducing his W-2 or her W-2 by that $100,000, and that means that that's $100,000 not currently subject to income tax. Because this is a welfare benefit plan under the statute. Any form of an employer-funded life insurance for individuals is deemed a welfare benefit plan. And because it's not a qualified plan, it means we don't have to have a trustee. That means we got the employer expensing $100,000 a year. The employee is taxed not on the amount of the premium. That the neonatology case speaks to this. They are rather taxed on the economic benefit. The economic benefit is now referred to as a Table 2001 or the employer's 1-year term. So that means we have, it's about 6% of what the amount of the premium is would be deemed the economic benefit for that individual. So that means he's putting away 100,000.
Yep.
He's going to be taxed on the income to him, let's say it's $6,000. He's at the 40% rate. That would be, if I take my shoes off, that would be $2,400 is all of the income tax that he would pay Uncle Sam.
Yeah.
Then, and if you do that for a number of years, you could actually have, if you start when you're 50, you do it till you're 67, that means you've put in $1.7 million over that period of time, subject to a minimal tax. Word of warning, the economic benefit will increase each year a little bit.
Sure. Yeah.
However, why, as opposed to with a split dollar arrangement, and we'll get into this later, but with split dollar, your economic benefit runs forever, or you die. But for this, it's because of the direction from the code, the income tax, the economic benefit stops when you stop funding. That's particularly helpful to the executive because as we get older, I referenced you have a greater economic benefit each year. So you then have, because the policy was owned from the inception with a co-ownership arrangement, so that the death benefit was assigned to the plan, no trustee, the individual or his estate planning tool will be able to own the policy.
Yep.
There's another tax that we haven't talked about on the effect of the employee, and that is the transfer tax. If he or she wanted to take that policy out of his estate for estate tax purposes, it's going to be the tax code specifically indicates that the economic benefit is the Table 2001 rates or the 1-year term. So as opposed to it being $100,000 transfer subject to transfer tax each year, it's going to be that the first year, it's going to be that $6,000. So that means you can make a gift of, I think, $17,000 a year. You'll be able to move that asset out of the estate at the same time that you're using substantially before tax dollars to do that funding.
Wow. Yeah. So in summary, then it seems that 1, you're funding the future comp, 2, significant tax avoidance, and 3, simplicity of execution.
Yes. The only filing requirement, because I've been a tax attorney since the early 70s, and during that period of time, I had to go through a plethora of annual filings for deferred comp and or nonprofit arrangements. There is just one filing required one time. That's an e-filing with the Department of Labor, because this is deemed a top hat plan. And with the e-filing, this started in 2014. It means that it's 2 pages. You show the employer's name, other statistical information. You don't even have to name the people that are in the plan. So that's the story, and we stick to it.
Very good.
Okay, hey, Larry,
Yes, Pat.
you've mentioned a number. Well, one of the things that you've mentioned that we need to clarify is you've started to mention the use of insurance, life insurance, as the vehicle to make this solution happen. Well, with deferred comp, you don't have to use life insurance. I mean, it can be completely unfunded, and you're going to pay deferred comp out of future earnings and so on and so forth. What are the advantages to using a life insurance contract when it comes to either deferred comp or this solution, which is this solution is you're referring to it as a welfare plan. And
Yes.
in a welfare plan under which section of the code again?
The welfare plans are governed for measurement purposes under 419 and 419 Cap A. In the same way with a qualified plan that our listeners may be familiar with, you make a contribution, you get a deduction into a 401A plan, and then the measurement is described under 415. With the welfare benefit plan, your contribution is measured under 419 and 419A. And what that says is you can deduct the cost of the current death benefit funded over the working life of the employee, brought back annually to the present value.
Okay, so did you just answer my question then about why insurance in this particular situation, because of what you just said there as to what 419 says in regard to the deduction?
The other part, and being a lawyer, I can talk forever, I apologize.
Yeah, we'll cut you off when we need to.
Good. With the funding into the life insurance policy, a life insurance policy is actually a huge tax shelter. That to the extent that you are building up cash value, regardless of whether it's whole life or UL or IUL, that money is deferred until the policy is surrendered, the tax on that, so that it means you're getting more muscle into the alternative to the deferred compensation. And then if you pass away previous to withdrawal from the plan, then you get this huge death benefit available to your loved ones. If you terminate by way of retirement or going to company B as opposed to company A, then you have a portability, availability, and until such time as you surrender that policy, if it's not a modified endowment contract, then you will be able to access cash in the policy, further income tax deferred as long as the policy stays in effect.
All right, good. So we've talked about nonprofit execs, and we work, actually, Walter's firm does a lot of work with nonprofits, and so that's applicable. But most of what the clients that we're mostly working with are for-profit business owners. That's our listeners for the most part. And so let's bring it down to grassroots for a business owner who, let's say they have 5 partners, and they're different ages, different stages of life, and they're thinking about exit, and they have some real values-based goals that lean toward them not wanting to sell to a third party eventually. They may want to do an internal sell to key management team, or maybe even they might even be thinking of doing an ESOP. How could this solution, and sometimes, as I mentioned earlier, we use non-qualified deferred comp as part of the piece of this puzzle in structuring a buyout. How could this solution be implemented in a situation like that?
Pat, the approach that I've described has application in the different fact patterns that you shared with us, because you could have this policy, the underlying policy, either be owned by the employer, so they get a deduction at the front end with the cost of the current death benefit actuarially determined, and that will qualify as an income tax deduction, not just for a C Corp, but also for any form of pass-through entity, whether it be an S Corp or the LLC or LLP. So it has application also with professional service companies. And because it's not a qualified plan, you're not in lockstep, so that where you have 5 partners, and if each one doesn't have 20%, maybe they have a variation. We can have, under the rules for 409 Cap A, D1, bona fide death benefit plans, we can have different face amounts of the policy as well as different funding. It's not like a 415 that you got a 10% or a 20% or a dollar limit. There is no percentage limitation, nor is there any dollar limitation other than the availability of the coverage based upon the health of the individual. So this can be, if it's employer funded, you would then qualify. Employer funded, employer owned the underlying policy. We've got the actuarially determined cost of current death benefit as a current deduction. And then if it's employer owned, when the participant leaves, the employer gets a second income tax deduction based upon the taking money from the policy, where it was owned by the employer. Taking money out of a policy is not currently subject to income tax, and you can then expense and deduct the amount that's given either by deferred compensation or by way of buyout. If it's a buyout, you're not going to be able to deduct it because you're getting the stock back or the shareholder interest. If you wanted to have it so that it was employee friendly, you could have the policy issued at the beginning, so it's owned by the employee. The employer still gets that same deduction on day one, being the cost of the current death benefit. The participant gets taxed on the economic benefit, that small figure that we discussed, about 6% of the amount of premium, and then they own the underlying policy, so that then when they terminate, there is no transfer. The co-ownership evaporates. We've got a BOLIP, a big old life insurance policy. We have low basis, but to the extent that money is borrowed from the policy and the policy is still being in effect under current income tax laws, that those loans are not subject to income tax. So as long as that policy is maintained till the death of the individual, we actually will continue to avoid income tax. So that's
Larry, if we're dealing with, oftentimes it may be an older person as they're getting ready to exit their business.
Right.
Insurability becomes an issue, correct?
Yes, it does. Under the statute, and it was only in 2016 that with the final regulations, proposed final regulations, it incorporated by reference another section of the code, 31.3121, for the definition of what a bona fide death benefit plan is. And under that section, you can also cover dependents, so that if the OF, the old folk, is uninsurable, we could actually put the life insurance on a family member as a dependent. And then when we stop the funding, the participant, the withdrawing individual could access cash in the policy. It also economically works out very attractive if you got somebody 67 who's walking away, and the life insurance funding for 5, 10, 15 years was on a 30-something, a child of the withdrawing partner. The mortality cost is much less for that 30-something as opposed to the 67-year-old. So you actually it may be economically more efficient to cover another family member.
Interesting. And
Okay.
from a timing standpoint, oftentimes
Mhm.
we encourage listeners to start their exit planning, ideally from day one when they first start their business. But knowing that usually isn't the case, we're thrilled to get somebody who's got like a 3 to 5 year time frame. But what if we're in a situation where we have a 1 year time frame? Is that enough time to implement some strategy like this, or not really?
I recommend that people have at least a 3 to 4 year funding period to be able to get. The issue is not the plan itself. The plan itself could work, but it's getting enough money into the policy so that it can become an alternative to deferred compensation. And also, if we did a big dump on day one, in order for it not to be a mech, and when I'm saying dump, I'm referring to putting money into the policy, that then the amount of death benefit with that large of a premium would be excessive, and there'd be less. There's a greater draw on the cash inside the policy because of the greater mortality. So it's generally 3 to 4 years. If it's a spike that the employer has, in other words, for 1 or 2 years, they're going to make a lot of money, and then because of business cycles, they know it's going to go down. We could actually use over and above the traditional premium amount. We could provide to the carrier a premium deferral account, so it gets off the books of the employer, so that the employee is protected, and then over the subsequent number of years of the funding, it comes from the insurance carrier directly into the policy. So there's ways to mitigate the issues, but it's still best to have a number of years.
Yeah, that makes sense. Thanks.
Yeah, so in our world, our owners, we're, excuse me, we're trying to help them figure out what exit route is going to make the most sense for them, and then put a plan in place for that. And so typically it's going to be either a sale to a third party, sale to insiders, transfer to kids, or an ESOP. In almost all cases where it's a sale to a third, or sale to insiders, or transfer to kids, deferred comp is at least brought into the conversation as a potential piece of the deal structure. But with third party, when we're helping someone plan for a third party, or certainly an ESOP, it's not coming up, and for I think some pretty good reasons. Would you say that we're thinking rightly there? If it's a third party sale, if someone's planning for a third party sale, there's really no good reason, unless it's to retain key employees. But in regard to the owners themselves, is there any good reason to consider deferred compensation on an owner who is dead set on selling to a third party in the next 5 to 10 years?
Because we still have long-term capital gains, and if that's the route that you're going, you might want to mitigate some of the tax and also create a lifetime benefit for the seller, so that it would be a deduction by the new owner of the company for the continued payment of that death benefit. And in turn, the owner, the former owner, could have as a portion of the revenues that they receive, not just the lump sum on day one, but also many times you have an earn-out provision, so that the the former owner doesn't get all their money at once to the third party. They then have a continued revenue stream for maybe 3 to 5 years. You could convert that taxable stream that would be going to the former owner. You could reduce that by the amount of the contribution that the new owner makes. It also becomes attractive to the new owner because that contribution amount, similar to deferred comp or severance pay, would still qualify for an income tax deduction at the new owner's level, and it would be less tax based upon economic benefit to the departing owner.
Makes perfect sense. Yeah.
Okay. What about, so, would it show up on a balance sheet then? The welfare plan, does it show up on the balance sheet as an obligation?
Actually, no, because the policy itself would be owned by the seller. There's an expense still going by the new owner, so that they would be getting a deduction for that. But the asset itself is not on the books of the employer, particularly in the nonprofit field, where you have a tension between the employee slash physician at the hospital or the sports or the coach at the university. This is a way that they can feel more protected, that they're not going to have to go back hat in hand uh, looking at going after a 457 plan or a 403B plan for their benefits. They will be, when they are no longer eating out of the trough at the university or the hospital, they've got the policy, and then they can do what they want with it without any direction from board of directors or officers of the continuing university or hospital.
All right, very good. Okay, we've gone quite a long time here. Any closing thoughts or wisdom that you would share here to close, Larry?
Well,
Is there anything that we should have asked that we didn't ask?
Yeah, right.
You're not an attorney or prosecutor, right? Okay. We've shown how there could be an income tax savings, a excise tax savings.
Mm-hmm.
There's a big tax that's coming down the road, and that is right now, people have a non-taxable estate of slightly over $12 million.
Mm-hmm.
And if it's a husband and wife, that's 24 million. So there's not a whole lot of people that have been doing planning based upon estate tax or transfer tax savings. Come 2026, that 12 million per person reverts back to 6. So there is, particularly in the Washington metropolitan area, in many urban areas, there are families, particularly owners of closely held businesses, that will be affected by the estate tax levels.
Mm-hmm.
So this is, as you said before, the sooner you start the process, maybe it's not even for a deferred comp alternative. Maybe it's a way to fund for your estate tax. And this then would be the most economically efficient way to do it. And you could start doing it now. And then if you retire and you need to get access to cash, you can access the cash in the policy. And then, similar to like with an IRA, you just monitor that policy to make sure it stays in effect. So that I think it is an important takeaway for business owners. And it's not that you got to fund everything. If you get a bad year, these are permanent policies. You could skip a year. Policy, if it's 3 years or more, the policy should be able to maintain itself so that that benefit's still there. A interesting point is because the deduction is based upon the cost of the current death benefit, that plays off of the face amount of the policy. So even if you don't fully fund the policy in any 1 year, you still qualify for the full deduction. So that's a happy accident under the Internal Revenue Code.
All right, so we've gone longer than expected, and I appreciate you taking the time. I do have 2 more questions though. So we talked about the disadvantages of non-deferred comp, conventional non-deferred comp. What are disadvantages to the welfare plan?
Every parent thinks that their child is the smartest and the prettiest. So for me to say that there's a cost to it, there is. And that is that in order to be assured of the income tax deduction or the expense amount, you would retain an actuary annually to support what that figure is. So that is the administrative fee that would go on as long as the funding of the policy.
All right, and is there a percentage or some kind of idea of cost that you can?
Yeah, it's generally 3 to 5% of what the amount of the contribution is, what the amount of the premium is. Okay. So that's the rule of thumb. It's actually pretty similar to what you see in defined benefit plans. Nationwide average for the admin fee of a defined benefit plan is 3.2%. So
Okay.
it
Is there
seems
any other disadvantage that comes to mind other than the ongoing admin fee?
the insurability issue is always a concern, but through the advent of the pandemic, there are many carriers out there that will permit online enrollment for the coverage. And one, an insurance company up in Pennsylvania, you can get $7.5 million a face and up to $2 million premium without having any medical exams, just your DUI record and your pharmaceutical list. So, and it's a planning tool, as we've said. This permits for lifetime planning as well as death planning, buy, sell, deferred comp. It has a lot of application.
Okay, so one more question. When would you use, are there situations where you still use what we've always used in the past, the standard non-qualified deferred compensation solution versus this solution?
Sure, I mean, facts change, but if what you're doing is you want to cover your mid-management, middle management, and it may be that the level of the funding annually is $5,000, $10,000. It's not worth it to go through the structuring that we've just discussed. But if you're talking as a total group of over $100,000 of premium of funding, then you have the attraction of qualifying for a current income tax deduction for all or part of the contribution, and then you have many steps of flexibility down the road.
All right, very good. Okay, Walter, Corb, any last questions from you guys?
The only one I had, which is simple, and I'm stuck back on that, insuring a child. The parent, how do they actually access then the value if the child?
Just because a child, okay, just because a child is the insured doesn't mean they're the owner. You can have there's, I mean, when I was growing up, there was the Gerber baby, and they actually had an insurance wing. So I ran an example where, as opposed to putting money in a 529 plan for a child, if you, this never came to fruition, but it's a good story. If you put that same amount into a life insurance policy on that child, you got huge benefits when the kid was 62. So but it's just a tool.
Basically, it gets down to ownership, Corby.
Yeah.
Whoever owns the policy controls the cash in it.
Yeah.
All right. Well, Larry, thank you so much. This is great. So listeners, if indeed deferred comp is mentioned by your exit planning advisors or whoever's advising you on exit, you might mention the welfare plan and just ask if it would be more appropriate, because it does seem to provide a lot of the same benefits. It can solve a lot of the same problems. Attracting, retention, rewarding key employees. It can still be used the way deferred comp is, and structuring a deal for exit with an internal sale or transfer of children. And yet there's ways to, using this strategy to actually realize some tax favorability and benefits that you might not with traditional non-deferred qualified compensation. So Larry, thank you. How can folks contact you if they want to and get more information on this?
I can always be reached by texting or phone 240-604-6945, or you can reach me at larrybell@theuniquesolution.com. Thank you.
Excellent. Thank you so much. We appreciate it. And listeners, if you want help in planning for your eventual exit or building your business so that it is transferable or sellable, you can get in touch with us today at exitreadiness.com or email at exitreadiness.com. And if you use the code podcast when setting up a free exitreadiness.com account, you'll receive a 10% discount on any products, virtual products that you purchase there. Make sure to listen in next time. Thank you. If you've enjoyed the podcast, if you benefit from it, please like it on the different social media channels. Until next time on the Exit Readiness podcast, this is Pat Ennis, Walter Dial with Corby McGordon signing off. Thank you.